Hey, Nate Webb from the Webb Law Firm. I'm here to talk to you about what to expect as a pretrial condition of release. Are you going to go to jail? Are you going to have bail imposed? I know an arraignment is a very scary thing, especially if you've never been in trouble before, which is, probably 90% of my clients or more. And so you're concerned about, do I need to call a bail bondsman? Am I going to walk out of there today? So, normal conditions of release, standard conditions is what we call them in the field, would be things that involve just maintaining law-abiding behavior, such as, no new criminal law violations, don't drive unless you're validly licensed and insured, let the court know if your address changes. Some courts might impose an abstinence condition, and then don't refuse any breath or blood tests from a law enforcement officer if they pulled you over during the pendency of this case and they had reasonable grounds to believe you were driving under the influence of something. So those are the standards. But what I really am here to talk to you today about is when they get a little bit higher than standards and why that would happen. So if you're a first offense DUI in most jurisdictions, whether it be Pierce County, King County, Snohomish County, if you don't have any prior offenses and there wasn't some wreck or a child in the car, then those are going to be your conditions of release, what I just talked about. Now, if you have a prior offense or if you have a history of failures to appear on other maybe criminal matters you were involved in, whether it be a prior DUI or something else, the court may impose bail. If you, especially if you missed the arraignment, they might impose bail. A lot of times you might have had to already post bail to get out of jail. So some officers will book you into custody, and you're required to be booked into custody if you ever had a prior offense. But if some jurisdictions will just do it as a matter of course. Many jurisdictions, Washington State Patrol, sometimes will just release you after the breath test or blood draw, and you're free to go. Take an Uber. Sometimes you might even get a ride home by the officer. It's not uncommon. But whenever you have something more egregious, so to speak, history, failures to appear, then you're going to have a likely bail imposed, and that's to make sure or ensure that you're going to come back to court. Okay, so the court is concerned about your appearance. Okay, the other thing that a court might impose, if they're concerned about community safety, is how they'll basically phrase it. The prosecutor might say to the judge, "We're concerned about the safety of the community, Your Honor," and the judge may agree in some instances if you have many prior offenses. And so the court then would likely impose an alcohol monitoring device. If you have a prior offense in your lifetime, and a prior offense is defined under Revised Code of Washington 4661-5055 as anything that was originally charged as a DUI and reduced to either a reckless endangerment or a negligent driving in the first degree or a reckless driving, which is one of the more common ones. If you've ever had one of those, or if you had a DUI conviction or you were found guilty after a jury trial, an acquittal wouldn't count, a dismissal wouldn't count. Not deferred prosecution, but a just straight up dismissal for something else. So if you've had a prior offense in your lifetime, the court is going to have to impose an ignition interlock device as a condition of release. There is a not so recent statute, but in the time that I've been practicing, they didn't always have this, but they imposed now a condition that anyone who has that prior offense must install an ignition interlock device. Now, there are a couple of exceptions to getting around that. One is if you don't have a car or something like that, then you can sign a declaration of non-driving. And the court may then go ahead and say, okay, just as long as you're not going to drive, you're telling the court you're not going to drive. If you do so, then we're going to have a talk about it at another hearing. Another option would be some other type of alcohol monitoring device. And so that might involve what is called a soberlink device, which is a handheld portable breath testing system. And what it does is it takes a sample of your breath, as you might expect, much like the one that the officer may have used with you on the side of the road. If you didn't encounter that, you wouldn't know what I'm talking about, but here's what it looks like. And you basically hold it, you push a button, it's synced up to your phone through an app, and it also has a camera, a small little camera to make sure it's you that's taking the breath test. And you probably have to do that maybe 3 or 4 times each day, and it'll be reported to the court. So that's a way to 24/7 alcohol monitor you if you couldn't do the ignition interlock and the court still wanted to monitor you. The other would be a scram device, and this is a device that you would have to put onto your ankle. It's not necessarily a GPS monitoring device, much like home detention might be, where it it sees your location. But this device is detecting alcohol in your system. And so if you use hand sanitizer or anything like that, it can be picked up through that scram device, okay? And so you need to be very cautious, and most courts will tell you this when they impose this as a condition of release, that, we've heard it all, so don't try to tell us you used hand sanitizer and didn't know, okay? So hand sanitizer, mouthwash with alcohol, and of course anything that if you might consume any dinners or something that might have been cooked with white wine or things like that. So you want to make sure you avoid that type of stuff, because scram is a pretty restrictive device and it'll catch everything, okay? And there's no getting around it. I've heard all kinds of stuff, people sticking salami down in between the reader and their skin. It just there's no way around it, okay? So don't even try to tamper with it, it'll catch it. So those are the conditions of release if you had a prior offense or if the court is concerned about community safety. But in most instances, probably more than 80% of the time, it's going to be those standard conditions of release that I talked about, and you'll be able to walk out on your personal recognizance. And even when you have those alcohol imposed devices, you're still going to be released on your personal recognizance, meaning that they aren't going to take you into custody or remand you on the spot, but they'll let you be free to go with those certain conditions to abide by. But in the majority of the cases, it's going to be those other ones I talked about without the alcohol monitoring devices or bail. And so if you do have questions about that, if you're concerned about that first court appearance, feel free to reach out to me. I've been doing this for over 21 years, and I've helped thousands and thousands of people across the Puget Sound region with their DUI and DOL administrative hearings and all that comes with it. So feel free to reach out, and I'm happy to answer any questions that you have.